Ted Cruz recently said to Mark Zuckerberg at a Senate hearing, quote, "The predicate for Section 230 immunity under the CDA is that you're a neutral public forum," end quote. But that's wrong. The law doesn't say that. Josh Hawley recently said in an interview with Dana Lash, quote, "I think of it as a repeal of 230, this key question about whether or not Americans can go to court and be heard if they get censored. That's what we ought to give the people the power to do. You can do it against the newspaper, you can do it against a TV station, you ought to be able to do it against Facebook," end quote. But again, that's wrong. You can't sue newspapers and TV stations for censorship. In October, Donald Trump tweeted, quote, "The USA doesn't have freedom of the press, we have suppression of the story or just plain fake news. Repeal Section 230, end quote." That's so embarrassingly wrong. We do have freedom of the press. Then this week, Justin Amash tweeted, "You tell me why you're upset about social media companies, and I'll explain why Section 230 is not the problem," end quote. Wait a minute. Wait, that's right. That's the tweet. First and foremost, I'm not a lawyer. Plenty of the folks sourced in the description below are lawyers, but the following are conclusions the result of my own research and should not be used as legal advice. Section 230 of the Communications Decency Act has become a bigger and bigger topic of discussion over the last few years, especially ever since Donald Trump became convinced that it's the only thing stopping him from exerting control over social media companies. To aid in his crusade, conservative media outlets like Fox News and conservative politicians like Senators Ted Cruz and Josh Hawley have started to peddle this narrative that tech companies are unfairly suppressing conservative voices and that they're allowed to do so because of Section 230. Consequently, your average conservative voter now thinks that conservative censorship on social media is a serious problem that is enabled by this 26-word piece of legal minutia. To be fair, Section 230 has taken its fair share of abuse from the left as well. After the 2016 election was influenced by foreign efforts via the spread of misinformation and propaganda on social media outlets, liberal politicians started questioning whether Section 230 protected social media companies from having to address the problem. The same goes for hate speech. In both the Christchurch and El Paso shootings, the shooter posted hateful manifestos that highlighted the ways in which he had been radicalized by extreme online communities. Now, Nancy Pelosi, Adam Schiff, and even President-elect Joe Biden have suggested revoking Section 230 in response to the hesitance of these social media platforms to, in their minds, adequately address the use of these platforms in spreading misinformation, disinformation, and lies. Now, in my video a couple weeks back about the Dominion voting systems conspiracy theory, we talked about how the best thing websites like Twitter could do to stem the spread of misinformation is to ban repeat offenders, especially if they're prominent media or political elites, even if they're the president of the United States. However, that's not a Section 230 issue. None of this is a Section 230 issue. Section 230 writes into law that third-party speech presented on a website cannot be treated as the speech of that website for legal purposes. In other words, Section 230 says that the things I'm saying in this video posted to YouTube cannot be treated as the speech or expression of YouTube. Even though YouTube provides me a platform to share my video, YouTube cannot be treated as the creator of the video. I'm the creator, and I alone am responsible for the content. Section 230 further clarifies that websites have the right to moderate third-party content, but it's important to keep in mind that the purpose of this clarification is really just to protect websites from frivolous lawsuits, because the First Amendment already gives websites this right. Remember, the First Amendment is a negative right against the government. It says what the government can't do. If YouTube were to take down my video and I sued them for doing so, a judge would promptly remind me that the First Amendment prevents the government from compelling a private company to keep my video up. I would have to somehow show a pattern of YouTube discriminating against me on the basis of a protected class, of which political identity or ideology or affiliation is not one. And really, this is the whole crux of the issue. The First Amendment protects people and companies from having their speech and expression regulated by the government. It does not protect people from having their speech regulated by other private entities. It doesn't matter whether the company is a platform or a publisher either. That's just a semantic part of the argument that the right has become particularly fixated on. But Section 230 doesn't differentiate the two in granting these protections. It gives them to all websites equally. After all, websites can both be platforms and publishers at the same time. YouTube is a platform for users to publish their own content, but it's also occasionally publishing its own content on the same platform. YouTube is legally liable for the content it publishes. It isn't for the content that other people publish. The distinction is not whether or not YouTube is moderating the content, it's whether or not the content being published was actually created by YouTube or the third party. That decides whether or not they can be sued for it. If Section 230 were to be rescinded, it would make all websites that rely on user-generated content very difficult, if not impossible, to exist, because it would be really easy to just bankrupt them with frivolous lawsuits. We're not just talking talking about social media either. Blogs like WordPress or Tumblr, content hosting sites like SoundCloud or Patreon or Twitch, Wikipedia, all of it would become a burdensome liability. They really wouldn't be able to exist. Meanwhile, the problem that these conservatives are complaining about is really hard to substantiate with data. It doesn't seem like social media sites are unfairly suppressing or silencing conservative views because they disagree with the politics. It's because they break the rules more often. At any given time, the top shared content on Facebook is usually from conservative creators, and Trump himself has been able to baselessly accuse people of murder on Twitter without much repercussions. He doesn't get his tweets flagged more because he's a Republican, it's just because he lies a lot. At the end of the day, if the government were to start telling private companies how they can or can't regulate the content that's posted on their websites, the government would be violating the First Amendment. That goes for hate speech and lies just as much as the so-called censorship or suppression. This is a problem for the market to fix, not the government. If you think Twitter is unfair to conservatives, go to Parler like you all keep saying you're going to do. That's literally what it's there for. The government can't enforce or mandate political neutrality. That's why Reagan rescinded the Fairness Doctrine. Now, it was one thing when you were talking about TV broadcasts. There are only so many hours in the day. It's pretty easy to quantify how impartial or biased a TV network is being, but this is the internet. Hundreds of hours of content get uploaded to YouTube every minute, and that's just one website. Now, that doesn't mean that the government should completely keep its hands off of social media, the internet, and big tech companies. The internet is a really big place, and there are plenty of ways that people are and will be exploited or taken advantage of, and the government needs to think carefully about what it can do to protect customers and voters. One relatively easy thing that the government could do to help consumers maintain at least some agency in the way that they participate with these platforms is around feed algorithms. Most social media and content platforms, whether it's Facebook or Twitter or YouTube or Spotify, use algorithms to push content to users. Some of these algorithms legitimately improve the user experience. For example, I've discovered a ton of new artists because Spotify's algorithm is really good at knowing what kind of music I like. However, other algorithms exist purely to keep the user's attention. Consequences to the user be damned. For example, the Facebook algorithm will feed you information that it thinks is most likely to make you keep scrolling or sharing, even if that information is false or if it's geared to make you angry or upset. While the government can't regulate the ways in which the platform moderates that content, it can make the platform give you the option to opt out of the algorithm altogether. Don't sandbag the content my friends are posting just because the algorithm thinks it's less likely to get engagement from me, or promote the content that the algorithm thinks is most likely to get engagement, even if it's negative engagement. Give me the option of seeing the content that my Facebook friends post as they post it, regardless of whether or not the algorithm thinks I'll like it. If you don't think this will have a big effect, do this experiment for me. Go to your friends list and open up some random person's page. Chances are that you're going to see a bunch of stuff that they've posted that never showed up on your feed. It's not necessarily because of that person's politics or because who they voted for or anything like that. It's just because the algorithm doesn't think that you'll like it. Or more specifically, it doesn't think it'll keep you on the platform. You should have the right to opt out of that. Also, if we really want to prevent political discrimination, let's start with voting and districting. In 2019, the Supreme Court ruled that courts can't do anything about states drawing districts in a way that will dilute the political will of certain Americans based solely on their voting habits or the politics of those Americans, because one's political affiliation isn't a protected class. As a result, political majorities all around the country are districted out of representation. For example, look at Texas's 2nd around Houston, where Dan Crenshaw is the representative. Look at this nonsense. This doesn't make any sense. The district is only drawn this way to break the urban liberal bloc in Houston into a bunch of little pieces and dilute them with conservative areas around the city. It completely warps the representation of the area and it disenfranchises voters. But I don't hear Josh Hawley or Ted Cruz complaining about that, and there's no mystery why. So how about this? Allow this liberal to dabble in some traditionally conservative sensibilities for just a moment. The government shouldn't get involved in the speech or expression of private companies or private citizens. They shouldn't get involved in your personal disputes with social media companies, and they definitely shouldn't get involved in ensuring that there's a safe space for your politics on online platforms. If you think you're being unfairly censored by a media platform, go to a different one, or better yet, make your own. What you definitely shouldn't do is threaten to veto defense spending bills, unless of course you have a good reason, maybe because they're not resourcing the welfare and health of the people who work for and in our armed services nearly enough, but definitely not because you got your feelings hurt on the internet. I'm Gerard LeConte. Thanks for stopping by and watching the video. Like and subscribe if you don't mind, share it with your friends. Have a great week. We'll see you next Sunday.